Well, good morning, ladies and gentlemen. Thank you very much, Mrs. Peterson, for the introduction. I regret that I cannot do this talk in your own language. So you have to listen to me in English, and I see that some of you have translation. I hope you are able to follow. I have been given quite a long slot in this program, and I hope that I will be able to fill it. And what I would also wish is that if questions come up or comments, that we can talk about these. It's a pleasure for me, of course, to be in Jurmala or in Riga. Some of you may have been at this same conference a year ago when the meeting was in Liepāja. And you may remember actually that, or may I tell you again, that the origin of my own family is in Estonia. My father was born in what is now called Tallinn, and my mother in what is now called Rakvere, which is a little town further east in Estonia. All of this, of course, long time ago. That was before the First World War, when this was still a province of the Tsarist Russian Empire. Now, of course, we live in a different time, and this is almost 100 years ago. I'm now come from Germany, and you heard a little bit about my professional background. Yesterday, I had the pleasure of being in Luxembourg, where there was a case in the general court, and the reporting judge actually was a judge from Latvia, Mrs. Raine, who has been recently appointed a judge at the general court in Luxembourg. So that already brought up yesterday some memories or expectations of what is happening here today. I understand that you are all judges. Is that correct? Or all of them, or some come from the patent office? Yeah. Or some administrators. So you are familiar with trademark litigation in its general sense. Of course, once we talk about the jurisdiction and the case law of the Court of Justice or the courts in Luxembourg, these are actually quite different from what happens at the national level. So when you talk at the Court of Justice, which is going to be my focus today, there are actually two ways of getting to the Court of Justice. One is what are called preliminary rulings. These are governed by Article 267. The TFEU is an abbreviation for the Treaty on the Functioning of the European Union, which is the central operating treaty for the European Union, its instances and its bodies. Since the Treaty of Lisbon, the Treaty on the Functioning of the European Union has taken over what used to be the European Communities Treaty. And then you have a treaty on the European Union, which has the basic constitutional provisions, among them the famous Article 7, which is now being invoked against Poland and may be invoked against Hungary for breach of fundamental rights and provisions in the European Union. Anyway, preliminary rulings are cases where a national court in the member states is of the opinion that its decision requires an interpretation of European Union law, an interpretation which it itself cannot give on the basis of the existing case law, and therefore it refers the case for a preliminary ruling on that issue of interpretation of community law to the European Court of Justice, which then gives a ruling, and the case comes back to the national court, which will apply that ruling in the pending case. In these cases, the Court of Justice itself does not decide the case, but rather it sends it back after the ruling to the referring court, which then takes the decision. The other way of doing trademark cases in the Court of Justice is by this provision. This is Article 72 of the regulation on the European Union trademark. The European Union trademark is the central provision governing trademarks which are administered at the European Union Intellectual Property Office. As you heard in the introduction, this used to be called OHIM, Office for Harmonization in the Internal Market. It now has a new name, European Union Intellectual Property Office, not to be confused with the European Patent Office, which is in Munich. The EU IPO, as it is abbreviated, is, as you may know, located in Alicante in Spain, where since 1994 the office has been administering the unitary and single European Union trademark. That office takes decisions in individual trademark cases, both what we call ex parte. Ex parte is in the examination of trademarks, you have to find out whether it's registrable or whether it's excluded from registration as a result of absolute or relative grounds in opposition proceedings. It also decides cancellation or invalidation or revocation cases when a third party brings an action against the registered trademark. And if you look at the numbers of these cases, the European Union Intellectual Property Office currently receives about 150,000 new trademark applications. I don't know whether you know whether that's a lot or not, but for example, if you look at China, I think they are currently receiving 6 million trademarks a year. 6 million. Imagine an office having to administer 6 million trademarks. It used to be half that only 3 or 4 years ago, so it's a growing, booming business. A country like the United States of America receives about 350,000 trademark applications a year. So compared to that, the EU IPO with its 150,000 is still a big office, but it's not the biggest in the world. These are examined, and then a number of them are refused, and when the examiner refuses a trademark, the applicant has the possibility of filing an appeal, which is handled by the boards of appeal of this office. You heard yesterday Mrs. Fink talking about EU IPO practices. She is on the Board of Appeal, and as you may remember from yesterday, there are currently about 19 members in the Boards of Appeal in Alicante, and they decide each year about 3,000 cases, or 2,850, 2,900 cases. That's still a huge number of trademark cases, so you have an enormous amount of individual decisions coming out of EU IPO, and if a person is not satisfied with the result of the decision of the EU IPO, boards of appeal, which may be taken in ex parte cases or in opposition or in cancellation cases, they can appeal to the Court of Justice. It's interesting, the article is called Actions Before the Court of Justice, but actually, as you see in the first paragraph, actions may be brought before the General Court. The Court of Justice in Luxembourg is composed of 2 courts currently. It's the General Court, which is also a first instance court for all actions brought against the European Union institutions or its bodies or agencies, and the Court of Justice itself, which is competent on appeals to decide against appeals brought against General Court decisions, but also the court where preliminary rulings are decided. So you have 2 ways in which trademark cases can come to the Court of Justice: on appeal from the General Court, or by way of preliminary rulings. And if we look a little bit at the numbers, and I'm talking now about 2017, 2018. I'm looking actually at the situation in the Court of Justice in the period from September 2018 to September 2017 to August 2018, so just the previous year. The Court of Justice usually stops operating in August, like most of the institutions in Brussels and elsewhere. That's the vacation period. There are no hearings in August, and they are just resuming now. We're being in the first or second week of the operation of the Court of Justice in Luxembourg. So the total number of cases that we are looking at is about 86 trademark judgments. And if you compare that figure with the cases handled by your highest courts, of course, no court, even in a country like Germany, has that number of cases at the highest court. 86 cases. These are divided into the categories that I mentioned, 6 preliminary rulings, and then there are decisions from the General Court on appeals, of which we have in this period 34, judgments and orders. Judgment and orders. The Court of Justice has the possibility of dismissing a case as manifestly inadmissible or manifestly unfounded by what is called a reasoned order. That case never goes to a hearing. It will be decided on the pleadings, and actually the Court of Justice has done so in the situations which we are looking at in 28 cases last year. So these are appeals brought to the Court of Justice by appellants who are dissatisfied with the General Court judgment, and the Court of Justice merely dismisses them without even hearing them. What is the basis for this? And we will see some of the arguments later. When you appeal against the decision of the General Court, the only issue that you can raise are what are called points of law. The Court of Justice does not review the facts, because the facts have been reviewed already by the General Court, but only points of law. And the Court of Justice has taken a very restrictive interpretation of what you might call points of law and questions of fact. For example, one of the central issues in trademark law is whether a mark is descriptive or distinctive, whether it is registrable in the broadest sense. And the Court of Justice has said that findings made by the General Court on the question of descriptiveness, distinctiveness are findings of fact and will not be reviewed by the Court of Justice unless the General Court has violated some rule of law in applying this. Similarly, the question whether there is likelihood of confusion, which is the other big issue in most trademark cases, whether they are in conflict with each other, is judged by the Court of Justice to be essentially a question of fact and not a question of law. So on these appeal cases which come from the General Court, in most of these situations, the Court of Justice, and I give you the numbers, 28 cases, they have simply decided, no, these are not issues which we are going to review. So in practice, a person who is dissatisfied with the first instance decision in the office has one complete review at the boards of appeal of the EU IPO. These are decided by 3 members. All of them have by now a huge amount of experience. Imagine that these 20 people decide 3,000 cases a year. So each of them obviously has seen most everything that you can imagine in trademark law. And then you have a review by the General Court. Again, a more or less complete review, except that you cannot introduce new facts. The General Court is composed of currently 2 judges from each member state. So you have a total of 56 judges until next March. You know, of course, that on the 30th of March, the United Kingdom will leave the European Union. And at that very date, they will stop to be members of the European Union. They will not send ministers to the Council of Ministers. They will no longer have judges in the Court of Justice, who will simply stop being judges in the Court of Justice. So the number is going to drop from 56 to 54, because then we only have 27 member states. But still, this is a very large number of judges, 54 judges deciding in the General Court in Luxembourg, having to deal with about 800 to 900 cases a year. And if you look at your own case load in your courts, or first or second instance, or in the Supreme Court, you will find that if you have a number of judges above 50 to deal with 800 cases, that's very generous. The trademark cases are distributed among the 10 chambers of the General Court, so each of the judges does not have too many cases a year to deal with. So whereas the great expertise in trademark law resides in the EU IPO itself and the boards of appeal, obviously the same expertise cannot be expected in the General Court. But still, the General Court has by now decided, I think, close to 3,000 cases in trademark law since the beginning, 3,000 cases. And so there's a lot of cases on which you can rely as precedent. And precedent is very important in our field. Why? Because some of the basic rules and principles, descriptiveness, non-distinctiveness, likelihood of confusion, and so on, are very general in their legal structure as general provisions, and they need to be filled in by case law. So precedent in our field is of particular importance, and everyone in the field of trademark law in Europe applies precedent when arguing cases. They find previous cases decided essentially by the Court of Justice, but also by the General Court, so as to facilitate analysis and decision of new cases. At the bottom of the screen, I have given you a few numbers which I previously referred to. There are about 6,700 opposition division decisions each year. There are about 730 cancellation division decisions each year. And the boards of appeal have about new cases of 2,800. These are rounded figures for 2017. And the General Court has each year currently about 300 new trademark cases, 300 cases. Again, that's a very, very large number, and you can expect that all kinds of issues arise, which are then decided by the General Court. What I'm going to report on are two cases where you have principles of trademark law, let's say new issues which haven't previously been decided. You have on absolute grounds 4 judgments and 5 orders, on relative grounds 7 judgments, and so on. I will, obviously, even though I have been given generously a large amount of time, I will not be able to tell you everything about every decision. So it's a selection of cases in the Court of Justice, focusing on issues of substantive law. Substantive law and infringement. Substantive law is what I call the centerpiece. You decide whether a mark is registrable on what we call absolute grounds, where the focus is on distinctiveness and descriptiveness. And the other focus is on conflicts. Conflicts arise when an earlier mark or right is brought forward against a later application, which may happen in opposition cases or against the later trademark registration in cancellation cases, or in infringement cases when the issue is whether the use of a later sign infringes upon the rights of the owner of an earlier trademark. These conflict cases are either likelihood of confusion or reputation, and these are the cases that I'm going to focus on. I already mentioned, if some of you were there last year, that, and I just want to repeat this because it's an important case for the future of our trademark law. We have, among the types of trademarks we talk about, the classic case of the individual trademark. A person files for protection for goods and services for his own trademark, individual trademarks. Then we have so-called collective trademarks, which are trademarks used by the members of a collective to indicate the common origin of their products, and we're going to see in a minute one of these cases. And then you have certification trademarks or guarantee trademarks. And these trademarks have become important for the future because the European Union trademark regulation now provides for the registration of individual, of collective, and of certification trademarks. And certification trademarks are marks which are used to certify that the products which are offered under this mark have a certain quality or certain characteristics. Think of certifying organs who certify security and safety of electric products or electronic items, and then you put a mark on there, and the mark is actually owned not by the maker of the product, but by the certifying body. And these marks, now recognized and registrable at the EU IPO, will also have to be looked at least in the national systems, because the directive on trademarks, which was adopted in December 2015, gives the possibility, not the obligation, the option to member states to introduce certification trademarks in their own system. I don't know what is happening in your country, whether the legislation to implement the directive is already adopted or in the process, but maybe you can tell me that later. The issue here is when you have a certification trademark, it must be recognized by the public as such a certification trademark. And here you see on the left side, this is actually a cotton, certified cotton, 100% cotton products. And the issue was, when you use such a trademark as a certification trademark, is this also sufficient to protect your mark from revocation on grounds of absence of genuine use? And the Court of Justice in that case, which I referred to already, answered that no, if you have a certification trademark and the impression is it's a certification trademark, you cannot rely on this as use for an individual trademark. And now applicants in Europe are owners of individual trademarks, are focusing on the question, if they are actually certifying qualities, but it's registered as an individual trademark, how can they avoid that these marks are contested on the absence of genuine use? I just want to remind you of this, that in the categories of marks with the certification trademark having been added, things have become more complicated for people when choosing trademarks. This is a case which is new, which I could not talk about last year. Everyone is familiar with Darjeeling. Darjeeling is a province in India, in the Himalayas, very high up, in above 1,500 meters. And it is well known for tea. I'm sure you're all familiar with Darjeeling tea. And Darjeeling, the word mark Darjeeling and the picture mark, the figurative mark below it, are registered as a collective mark for tea. The owner is the Indian Tea Board, which is a body responsible for marketing and promoting and protecting the name Darjeeling. And the question came up whether the tea board owner of Darjeeling for tea can prevent the use of Darjeeling on the right side for clothing. So tea and clothing are different products. So the question is, well, how could you argue that there is a conflict between Darjeeling for tea and Darjeeling for clothing? So the tea board argued two things. First of all, Darjeeling is famous. Or in language of the European Union, it has a reputation, and therefore it should also prevail over dissimilar goods. Dissimilar goods are goods which are not, under the likelihood of confusion analysis, those goods which are similar in nature, characteristics, and so on. That's the one argument. And the other argument, they said, I have a collective mark which consists of a geographical indication. This is actually registrable, even though geographic, because the European Union legislation provides that a collective mark may consist of a geographic name. It's not to be refused. And therefore, the test of infringement of this collective mark consisting of a geographic indication must be whether the public may believe that the infringing goods or the goods of the attacked, contested mark actually have an origin in Darjeeling, geographic origin, not commercial origin. So there are two questions. Can you rely on Darjeeling as a geographic name to protect it as a collective mark against non-similar goods on the basis of reputation? The answer is yes, you can. And then the question is, does the use of goods like clothing, is this to the detriment of the reputation or distinctiveness of Darjeeling? The court said yes for some goods, but not for all of them. And for the other goods, the question was whether the test of infringing a geographically descriptive collective mark is confusion as to geographic origin or as to commercial origin. There, the Court of Justice said in this case, we're talking about a collective mark which is protected only against confusion as to commercial origin and not geographic origin. So the Darjeeling people were left with a situation where they're able to proceed against some of the goods to the extent they're detrimental to their reputation. But they cannot rely on confusion as to geographic origin. There is also a different set of rules in place in the European Union which protect geographical indications as such. This is a regulation now called 1151/2012 on quality products in the European Union, and they have a section dealing with protecting geographic indications which are registered at European Union level, and they're very broadly protected against any interference or detriment. And they may be relied on exactly on this confusion as to geographical origin, But that is not true. That is not true for those which, like community collective trademark. The essential function of an EU collective mark is to distinguish the goods or services of the members of the association, the proprietor of the mark, from those of other undertakings, and not to distinguish those goods according to their geographical origin. This case actually was argued substantively and is an important statement about the function of collective marks, which are equal in their function to individual marks, because the protection is against interference with the indication of commercial origin and not geographic origin. Before I turn to absolute grounds, anyone has any questions on this, what I've said so far? It's going to be difficult if I only speak and you just listen, and we'll see how that works throughout the... Okay, we turn to absolute grounds, okay? Absolute grounds of refusal are of two types. The one type is grounds for refusal which must be applied a priori, which means a trademark which falls into this category cannot be registered regardless how famous or well-known it is. These are what we call the absolute exclusions. Signs, now new law, which consist of the shape or another characteristic which results from the nature of the goods themselves. Easy case, you cannot register the shape of an apple for apples. Of course, you can register the shape of an apple for a product which are not apples. You cannot register the shape of a chair for chairs, but maybe for other products. The shape of goods which is necessary to obtain a technical result. These are the technically functional trademarks. A number of cases have been decided, including the famous Lego block toy, which everyone has been playing with in his childhood, or maybe even as adults. This has been held by the Court of Justice to be technical because of the interlocking system. There are a few other cases, and then you have a third one, a shape which confers substantial value on the product. Very difficult to interpret. What is the value of a shape? Now, in the most recent legislation, which still needs to be implemented in the member states, but which is applicable in the European Union, you have added in each of these or another characteristic. So the absolute prohibition is enlarged to include other characteristics. There's by now a famous case, this one, decided about a few months ago in June. Anyone wears these very expensive shoes here in the room? Christian Louboutin is a designer of shoes, and his most famous, I'm looking at the soles of your shoes. The most famous design he has is the red sole. His shoes have a red, actually can you see this from, but you also have the printout in front of you. So this is a red sole on high-heeled shoes, and very famous. These shoes are expensive. This is a mark which is registered in the Benelux, in Belgium, Luxembourg, and the Netherlands. As you know, they have a single trademark system since 1970. By the way, did anyone ever think in your countries of making a common trademark system for the 3 Baltic states? The Louboutin sole was registered, and Louboutin brought a case against Mr. Van Haren, who was selling shoes which looked like it. No one doubted that they looked like it. But Mr. Van Haren said, no, this mark is invalid. It's a shape. You remember my text previously? A mark consisting of a shape, which is the product itself. So they argue this is the shape of the shoe. You cannot get protection for the shape of the shoe for a shape mark. So if you look at how the applicant described the mark consists of the color red, identified, applied to the sole of a shoe as shown. And then they added, the contour of the shoe is not part of the trademark, but is intended to show the positioning of the mark. So this mark is what we nowadays call a position mark. It describes the exact location that a mark may have on a product. And you may be familiar with position marks which are applied, for example, to the sides of shoes, if you think of stripes or decorations on shoes, or a particular indication placed on a product itself. So these are called position marks. And the question that was referred to, the Rechtbank Den Haag is the first instance court in the Netherlands, was this. Is the notion of shape, within the meaning of what I described to you, limited to the three-dimensional properties of the goods, such as their contours, or does it include other non-three-dimensional properties of the goods, such as their color? So the court was invited to judge whether, in this particular instance, when you apply a color to a part of a product, which is high-heeled shoes in this case, whether that complies with the notion of shape. And the case went up and down. What I mean up and down is it first went to the Court of Justice and had a hearing, and then they had the Advocate General conclusions, and then it turned out that the judges were uncertain and they wanted to re-argue the case, so they assigned it to the Grand Chamber. The Grand Chamber in Luxembourg is a composition with 15 judges, all the presidents of the chambers, plus the reporting judge. So this is a very high-profile case. It's like a plenary of the Court of Justice sitting in a case. They re-argued the case again, and then the judgment came out a little bit deflating for the people who were challenging this mark, because they said this mark, which is a sign consisting of a color applied to the sole of high-heeled shoe, such as that in the issue in the main proceeding, does not consist exclusively of a shape. It's not a shape. So the case is over. The mark can continue in the Benelux in the infringement because it's not a shape. Now people, of course, ask the question, I've set out a little bit in the subsequent slides if you want to read the arguments why this is not a shape. I think it's follows clearly. A shape is something which is three-dimensional, and it's certainly not color applied to some of that product, so I think the result is entirely correct. But the question is now, when you look at the new law, when you have or another characteristic, whether the case would be decided in the same way. Whether now, when you have a position mark and no longer the requirement that it must be a shape, whether the case will be decided in the same way. Most people, if you ask them, say, well, no, it's still not the product itself. Number one, it's obviously not technically necessary. And the value, if any, that this trademark confers on the product is not because of the color applied to it, but because of the use made of the mark and the perception by the public who recognize this as a Louboutin shoe. Absolute grounds. Distinctiveness. The so-called absolute grounds that I was talking about apply to all trademarks, and they cannot be overcome by acquired distinctiveness. So if you look at distinctiveness and descriptiveness as grounds for refusing trademark registration, these are the provisions that are applicable. Article 7 of the regulation and Article 3 or 4 of the directive, they are worded more or less the same. So I give you here a shorthand description of what distinctiveness is. Distinctiveness is a trademark, or it means that a trademark serves to identify the product or services in respect of which registration is applied for as originating from a particular undertaking, and thus to distinguish that product from those of others. You must have a reference to the goods and services for which the protection is sought, and to the public against whose perception the decision must be taken. This is, in a way, a standard definition that you find in many cases, and it may help you in assessing additional cases. Is this actually something which has the capacity to distinguish goods and services? And then we have descriptiveness. There is the definition of descriptiveness. Descriptive is a sign which tells you something about the product or the service. What it is, where it comes from, what its characteristics are, when it was produced. All of these are elements which we call part of the descriptiveness objection, and they are applied regardless of whether you can currently already show that someone is using that term as descriptive term or whether this may be true in the future. And you must make a judgment as an examiner or as a judge of whether a normally perceptive or attentive consumer would actually perceive this trademark as indicating something about the product rather than indicating the commercial origin. I wonder what you would do with a sign like this. It was in front of you. I indicated the classes for which the mark was applied for, 36, 30, 35, 36, 39, 42, but assume it is what it actually was. It's for services provided for parking cars, a parking garage or something. And so parkway, the examiner found by looking at this, and what do you do as an examiner? You go on the internet or you go into dictionaries and you find the word parkway used in English, or in England anyway, as something which indicates a parking lot near the railroad station or something. Parkway. I don't know whether you would have the same understanding. Of course, park has something to do with parking cars, but anyway, assume that parkway actually describes a location where you park cars. And then the question comes up whether if you add the graphic elements, the circle in green and black around it, whether that in green and blue around it, when you use it in color, whether this actually takes it out of the notion of descriptiveness. And this points to one of the current debates in European trademark law, which is not yet finished. What happens when you have a word mark or a sign and you add graphic elements to it? Does this escape the prohibition which would be applied in the absence of the graphic elements? The answer currently is that if you add simple graphic elements like simple color or simple circle or simple other designs, you do not escape the prohibition of registration. This is very frustrating to many applicants because in previous times it was thought that if you add something to a descriptive or non-distinctive word or element, you actually can escape the prohibition of registration. But this case, parkway, Abkur parking, is likely an important case for applying these principles in the future. Another issue that came up in that case, which is repetitive in many situations, the applicant said, I have a number of national registrations in a number of member states for the same mark, and I now want to have it registered as a European Union trademark. And the Court of Justice routinely says, no, you can make this argument, but it is not really relevant because we have our own separate autonomous system of European trademark law, and the fact that you have registrations in the national office is not decisive or not even relevant. An argument which, in the other way around, also applies that if a mark is registered in the EU IPO, doesn't mean that the same mark will necessarily also be registered in the national system because these systems are autonomous and independent of each other. So this I have, if you wish to read it in German, that case is not available in English. It's only in German and in French. But some of you may be able to read German and then can have a look at this issue of the effect of a national registration of the same mark. What would you do with a trademark like this? Is this a simple triangle, a simple basic geometric form? Is it registrable? The Court of Justice said in this decision that the General Court correctly judged this particular triangular trademark to be so simple as to be devoid of distinctive character. And I have indicated this is for a whole range of goods, classes 3, 9 to 12, 18, 22, 25, 28, 26. When I mention these class numbers, I'm sure you know that what I'm talking about, this is the NIS classification, International Classification of Goods and Services for the registration of marks, where all goods are ordered in a particular logical sequence. You begin with class 1, chemical products for industrial use, and you end with class 45. There are 11 service classes and 34 classes for goods. Now I have another case which I actually previously had discussed with you a year ago, but I want to mention it again. If you look at this this trademark, I'm sure you can read this better than I can. It's called Medved, and of course you know what that means. This is in English you would translate this as bear. It's an animal, and it's applied for meat products, sausage, so on. So the office said, first of all, the office said there are enough people who speak Russian or read Russian to understand what medved actually means. Secondly, bear for meat products is descriptive. Why? Because the product may be made of the meat of bears. Not very likely. There are not so many bears around that you can actually make a lot of meat from them. Anyway, it was refused on that ground, and it's a German company, Lackmann Fleisch- und Feinkostefabrik, and they were dissatisfied with this case. They brought it for the General Court, and the General Court last year decided rejection is proper, descriptive. And the issue was not so much whether, although it is, in fact, whether it is very likely that the product is made of meat from bears. Imagine you have a case called crocodile, and would then the product contain the meat of crocodiles? Or anyway, so the issue was whether it is, this being a Russian name, do you take into account a language which is not one of the languages of the European Union? So the General Court said, yes, there's a significant proportion of the public in the European Union which understands or speaks or reads Russian. And of course, if you look in your country, I think the population that is Russian in origin is still about 30% or 35%. And if you look at Estonia, it's not quite as high, but it's also not insignificant. Lithuania, I'm not so sure. So they said that is sufficient, and that creates a problem in applying our descriptiveness rules in the European Union, because there are other minority languages which are not official. Think of some dialect in Wales, which is not the official English language, or in Scottish, or the many languages spoken in Spain, which must now be taken into account under this rule. And when the case came up to the Court of Justice, what they were saying is that in judging the relevant circles of the trade, the General Court did not commit an error of law. So they simply refused to review the question of whether this is a relevant circle on the part of the public by simply saying that according to the case law of the court, all findings as to the characteristics of the relevant public and to its degree of attention are questions of fact, which we are not going to review. So all the arguments that the applicant made, look, we're not talking about whether the Russian publication perceives this to be descriptive, but we have a different argument, namely whether you take into account that part of the population which speaks Russian and which is not an official language of the European Union. The court simply disregarded it. Medved. We have another case which is absolute ground, called wind finder. Now, if you think what a wind finder may be, and you think of instruments of measuring and so on, you might imagine that these are instruments which help you to find where the wind comes from, or whether there is wind. And in fact, that is in part what the wind finder company actually was doing. This was rejected. The rejection was confirmed by the General Court, and when it came to the Court of Justice as one of the orders, we find the statement that the judgment must be confirmed because it's a factual issue of whether the mark is descriptive. And one of the arguments that are made by applicants in these cases is this is a mark which is new. That is to say, it's a combination of two words which you don't find in a dictionary. If you try to look up the word wind finder, no dictionary tells you that this is a common language word. But this argument is routinely rejected because they say even neologisms, or as they are called, combination of words, when they tell the public sufficiently clearly and directly what the product is or does, are excluded from registration. And I have two more cases which are in the same vein of marks which are not registrable. The city of Berlin operates its own heating and gas works, and they wanted to register the words Berlin Wärme, which means heating, and Berlin Gas, gas works sold in Berlin. Again, these are combinations of words which as such you don't find in a dictionary. You combine the word name of a city with a product that they're offering. But here again, they failed in their appeal on registrability, and these marks were rejected, and the rejection was confirmed. I have a final case out of the absolute grounds situations, and that is this one. I'm sure you're familiar with this product. Is it available on the market here in your country? It's the four-finger Kit Kat-shaped product. It's actually registered in this fashion in the European Union on the basis of acquired distinctiveness. A shape as such of this kind, if it's usual and common, will not be registered. unless it has acquired distinctiveness. Acquired distinctiveness means it has been used to such an extent that the public will recognize the commercial origin, will the maker in the abstract, secondary meaning in American law, Verkehrsgeltung, Verkehrsdurchsetzung in German, acquired distinctiveness, has become distinctive as a result of the use which has been made of the product on the market. The basis for that is, in the regulation, in the directive is the same. And here, the mark had originally been registered in Alicante upon application by Mondelez. Mondelez is the successor to Kraft Foods, and they make products like Milka, and did at the time Jacob's Coffee and others, or they are Cadbury if you're in England. They brought an invalidity case in Alicante, and they lost it. They lost it in the boards of appeal. So actually in the cancellation succeeded, but the Board of Appeal reversed, and the case came to the General Court on the central issue: if you show acquired distinctiveness, where do you have to show it? Everywhere in the European Union, in each member state? Or is it sufficient if you can show it with a majority of the population, the majority of the member states? And there was conflicting case law in Luxembourg, and the case went up to the European Court of Justice, interestingly, on 3 separate appeals, one brought by Mondelez, the other one brought by Nestle, the owner of the mark, and the third brought by the EU IPO itself, which was seeking clarification of the issue of where do you have to show acquired distinctiveness. And the case was decided, this just about 2 months ago, a little over 2 months ago, has become highly debated and subject to discussion. And what the court in the end said you must show that acquired distinctiveness exists in that part of the Union where it is lacking, and if the distinctiveness is lacking in the whole of the European Union, you must show acquired distinctiveness everywhere. Not sufficient to show it in part of it. Everywhere. You can present evidence which is more broadly and doesn't refer specifically to a member state, but in the end, you must allow the conclusion that the evidence shows that distinctiveness has been acquired everywhere, including in each individual member state. And that, of course, presents a huge difficulty for a company showing acquired distinctiveness in such diverse regions as Finland or Portugal or Malta and Cyprus. So we will see what's going to happen when the case goes back. But it is economically significant for companies showing acquired distinctiveness for a color or a shape, which will be more or less impossible to show for the whole of the European Union. So they are back at national level, and then they can show the acquired distinctiveness for each country. You have bad faith cases, very few of them. This actually I added because of it's such a funny name. Any one of you would understand this German name, Bauchwärmer? No, it's an alcoholic beverage, and it's Austrian slang. And Bauchel means stomach, a drink which warms your stomach, Bauchwärmer. And this is a conflict between two persons in Austria, where one accuses the other of having stolen that trademark. Actually, it's more of a litigation issue than truly bad faith. So now I'm turning to what we call relative grounds. This is conflict cases which are either double identity or likelihood of confusion, or marks with a reputation or other conflicts. Double identity is when both marks and goods are the same. Likelihood of confusion I have defined here when the marks are identical or similar. And the goods are identical or similar, and the public would likely to believe that the goods or services have the same commercial origin. What do you have to do? You analyze the similarity of the goods and services under an abstract test of nature, purpose, method of use, and so on. The case that I mentioned I had yesterday in the General Court involved the interesting issue of whether food for fish is similar to other products in the same business. So we get into the details of this analysis. And then you have marks with a reputation which are protected outside of likelihood of confusion. I have a few cases which I show you where you may agree or not agree that these are identical or similar. Champion and Champoil, what would you say? Similar or not similar? So the opposition division thought they're similar. The boards of appeals thought not similar. The General Court said not similar. The Court of Justice said not similar. Why? Because the element chem is not particularly distinctive, and actually it's champ and not chim. You argue these cases, and you may actually come to a different conclusion yourself. Conceptual differences between two signs may counteract their visual and phonetic similarities. So the chem versus champion shows you that these have a different concept and therefore are not confusingly similar. How about these signs for essentially the same services? They have the element ocean in common, which I would suggest to you is probably totally non-distinctive for a hotel placed on the island of Ibiza near the ocean. But you have kind of similar figurative elements. So you think these are similar? They will have to be similar, sufficiently similar. You disagree, right? I would also disagree, but you see, this is how, in the end, maybe it's the skill of the attorneys that they win these cases, because they say, look at these this circle is actually here. This semicircle is here. So you just turn the sign a little bit, and then it becomes more similar than it was before. No. And then, of course, they write ocean, and it's almost the same language, the same script. Look at the C, it's the same. Why do they have to, just the E is a little bit, why do they have to copy all of this? Why does it have to be so similar? So, how about word marks? P2 and Li2. Not similar. Even though they have 3 letters identical, not similar.
So how about Ocean Club Ibiza? Was it similar or not similar?
Similar. This one, similar, yeah. This is an issue which presented not the similarity of the signs, but the goods and services, which occasionally comes up. How you have, on the one side, roses and rose plants, and fruits and garden herbs fresh. Are they similar products? The court said no, they're not similar. They're the same class, but they're different. I think there you could also have a different view. Why are garden herbs and flowers planted in the garden not similar? They're placed in the same location. No, but of course they're a different nature. The flowers have a different purpose than garden herbs. There's another case raising a significant issue when you have what we call barely distinctive elements in an earlier trademark, like here on the left side, Optima, and you have the same barely distinctive element in the later trademark. And much of the debate in Europe goes on that issue. Do you actually compare the trademarks by taking into account these very weak elements. And while the office in Alicante would discount the weak element, the courts in Luxembourg usually take it into account. They say the public doesn't know that this is weak, and they have a prominent location in the mark, and so here, confusion. In this case, by the way, on the basis of identical goods. How about Sebo-Term and Seba? I'm sorry, it should be Seba-Term and Sebo-Kalm. The argument was that the Sebo is an indication of what the product is made for. These are pharmaceutical products. I'm not an expert to tell you what the ingredient is. But here again, the court said, the public doesn't know this. This is an ingredient indication, and the difference between Kalm and Term is not sufficient to preclude a likelihood of confusion. One can show, if you go to the case law of the General Court, literally dozens and dozens of cases where you can agree or disagree. And I'm just showing you some of these more contentious cases as they reach the Court of Justice. You then have marks with a reputation, very famous Kenzo, high-profile fashion in Paris and other places, and he was litigating against a person called Kenzo Estate for wine. And in this case, the earlier Kenzo mark prevailed over the Kenzo Estate for wine. How would you judge this one? You know, on the left is the famous Puma, on the right. The issue actually was not on the similarity of the signs. I think they are sufficiently similar to do something about it. It was the issue, these are non-similar products, and the issue was how you prove reputation of the earlier Puma marks, which they had relied on. So the case was actually a procedural one. Then you have conflicts between unregistered signs and registered trademarks here in this case. These are obviously the quasi-identical signs. The issue was whether the earlier sign, Bulgarian company, was able to prove that it had acquired rights in the earlier trademark in Bulgaria on the basis of use, and the office had said no, they had not provided any evidence. The board said no, they had not provided any evidence. And then the General Court said yes, the office should have taken into account what had been presented as evidence, and EU IPO was dissatisfied. So they brought a case against the General Court judgment, but they lost. The Court of Justice said yes, this is the evidence had to be taken into account. This is another one, Grand Hotel Palladium against Palladium. They are sufficiently similar. The issue there was, again, could the Spanish company prove use of its trade name in Spain in the relevant period? This is an interesting case where the issue was whether the earlier appellation of origin, Porto or Porto, used for port wine, could prevent the registration of a later sign, Port Charlotte, for whiskey. And the argument was made that, well, this is not possible under European Union legislation protecting appellations of origin. They could invoke Portuguese law, because Porto is also protected in Portugal, which provided more extensive protection. That's what the General Court had said. And then the EU IPO brought a case against the decision of the General Court, and in the Court of Justice, the EU IPO prevailed, with the Court of Justice deciding that the protection of appellations of origin which are registered at European Union level is governed exclusively by European Union law and not subject to additional protection under national law. So, infringement and defenses. The most significant judgment coming out of the Court of Justice very recently, 25 July, involved Mitsubishi. You know Mitsubishi as a company in Japan who make all kinds of products, including forklifts. Forklifts are these little engines that you drive around to lift products and put them in storage. So they were bringing in these, the defendants were bringing in forklifts that they bought, Mitsubishi forklifts they bought in third countries. Let's assume in Japan or in China, it doesn't really matter. Real, genuine Mitsubishi forklifts. They put them in a warehouse in, let's say, Antwerp or someplace in Belgium. They take off the trademarks, they erase them, put on their own trademark, their own numbers and their own identifying things, and they sell them as Duma forklift. No longer Mitsubishi on it. Question is the removal of a trademark from an original product and then selling the product with your own trademark, is that infringement? So if you look in your own doctrine and usages, you will probably find no, in most situations, the removal of the trademark is not infringement because you're not using the trademark anymore of the other person. But here the Court of Justice, to the surprise of many, held it is illegal, it constitutes trademark infringement in the situation I just described, importing original goods, removing the trademark infringement, Mitsubishi. That case has not yet, yes, I'm sorry, yes, thank you very much for putting this out. So this is very recent, and these cases may come before you. And what is still not decided is whether in cases of goods which are already on the market, assume you have a car, you take off the Mercedes, and you call it your own. No more Mercedes on it, you have your own trademark. Is that trademark infringement or not? We don't know. But if you import, the removal of the trademark before you put it under your own name on the market is trademark infringement. Another important case decided by the Court of Justice last December involved the defense of exhaustion. You're familiar with this product, I'm sure, but you may not know that the mark Schweppes is owned in parts of the European Union by the Coca-Cola company and in parts of the European Union by another company. There's a long history of Schweppes behind it. By the way, Schweppes is the name of a person from Switzerland who invented the process of putting carbon dioxide into water in the 1780s. So it's a long time ago. Mr. Schweppes emigrated to the United Kingdom, eventually came back to Switzerland, but he left his name Schweppes with an English company, Schweppes. And Schweppes, as a result of much of reorganization and resale, ended up in two companies. One is the Coca-Cola company, and the other part is the Japanese Suntory. It's a big brewery. They make Orangina and other products. So these products are on the market in Europe coming from different companies, but they look alike. They're the same, essentially. And the issue came when UK Schweppes was transported to Spain. Could the Spanish company say, well, I'm sorry, I own the trademark Schweppes in Spain. Could they prevent this parallel importation? And the Court of Justice said, yes, depends on the circumstances. When this is the answer that was, the question that was asked. And the answer is that if these conditions are met, that is to say, when you create the impression vis-à-vis the public that the marks, even though they're owned by two different companies, actually have elements in common, and on the basis of cooperation between the parties, that they are actually the same or have the same origin, then you cannot prevent it. But if you can show that you have not created this impression, then you can prevent it. It's an interesting single case of intra-EU exhaustion. Another exhaustion case involves the importation of debris soft, which is auxiliary products in patients' care, from Austria to Germany. And there is a case law on parallel importation of pharmaceutical products. Here they put a marking on their imported parallel product indicating who done it, just put a sticker on the product. And the issue was whether they are allowed to do this or whether they have to comply with the complicated rules of parallel importation for repackaged pharmaceutical products. And the Court of Justice said, in this case, you're allowed to do this. You do not change the original product. You merely put on it who is responsible for the marketing in the country of importation, so no trademark infringement. I have one important case on the issue of use. You know that in order to enforce trademarks, there is a 5-year grace period, and after the 5-year grace period, you have to put the trademark to genuine use, or you have to put to use a trademark which is somewhat different, but still essentially the same in order to be accepted as a variant. So you have a trademark registered like this, and you use only this. And in this rather unique case, the Court of Justice said it is sufficient if you use this in order to be able to enforce the combination. We're not aware of any other case where you have been so liberal, the courts have been so liberal in accepting that use of only part of a registered trademark is deemed to be the same as use as the trademark itself. The argument is that the picture evokes the meaning of the word. That's a new doctrine that has come out of Court of Justice, which I would suggest you not to apply, and it hasn't found much support in the literature. I could speak briefly about infringement, applicable law, and jurisdiction. Cases may be brought in European Union trademark courts on the basis of the domicile of the defendant with EU-wide competence, or if the defendant is not domiciled in the European Union, if he has an establishment in the European Union. Again, European-wide competence. So the German Hummel company brought a case against Nike, United States, on the basis of an establishment of Nike in Germany, which was the subsidiary not of Nike itself, but of another subsidiary of Nike in Europe. So if you wish, this is the grandchild of the Nike company in America, because the child is in Sweden and the grandchild is in Germany, and it is incorporated as a legal entity, let's say Nike GmbH. The question was, can you sue Nike America on the basis of this establishment in Germany, which is the grandchild of the actual defendant? And the Court of Justice said yes. If you have a stable presence from which commercial activity is pursued and has the appearance of a permanency to the outside, such as an extension of the parent body or grandparent body. So if you hold yourself out as being part of the chain, this is a Nike store, let's assume, established in Germany, you can establish jurisdiction in the German courts with European-wide competence over the American defendant, even though he only has an establishment in Germany. The other element which is important to know on bringing suits against absent defendants is a provision in the European rules on jurisdiction which allow you to bring a case against a defendant by joining another defendant who is established in another member state. So in this case, Nintendo, which is a Japanese company, sued a German company in Germany for infringement of its community designs, but it could have been trademarks, and they joined as another defendant the parent company of the German infringer who was established in France. So normally you would have to sue the French company in France because this is the rule for European-wide competence, but in this case you join the non-German party to the German party under this provision in Article 8 of this particular provision of European Union law. And the Court of Justice agreed with that in this particular case, which is design case, but actually applies also in trademark issues as well. So under this particular provision, you have the possibility of joining a foreign defendant in the local court and still have European-wide competence. I've finished, and I know that I'm already running close to your coffee period. The Merck, have you ever heard of the Merck companies in pharmaceutical industries? They're very famous. One is called Merck and located in Germany, in Darmstadt, and the other one is called Merck, located in America as a result of not expropriation, but a member of the family emigrated in the, I don't know, 1800s. And so they have two companies, same name, and they had an agreement since many years on how to separate their territories so they wouldn't be confused with each other. Obviously, the same name, Merck, a very unusual name for pharmaceuticals, is likely to be confused. So you have Merck and Co. in Kenilworth, in New Jersey, and you have the German Merck company in Darmstadt. And when the internet came about, and it was difficult to separate territories with advertising on the internet, they began to litigate against each other. There's a big case in the United Kingdom, and there's another case in Germany. I don't know why they chose this approach, but they litigated on the basis of a UK trademark in England and on the basis of the European Union trademark in Germany. And the question was whether the litigation pending in the United Kingdom prevented the later action brought on the basis of the European Union trademark in Germany. And the court said it doesn't prevent it if the relief, if the jurisdiction that is sought in the second instance doesn't include the United Kingdom, because then there can be no conflict. There is a complicated rule in European Union trademark regulation which deals with these co-pending actions under an identical European Union and national trademark. And this particular instance, the court concluded both actions can continue because they don't cover the same territory. These cases are still going on, and you can watch it. It's an interesting, actually a fascinating example of what happens as a result of migration, and you can do this with the Budweiser cases. I've recently looked at case law in the 1950s and 60s having to do with the word Steinway. You're familiar that Steinway is a famous maker of pianos. They actually were originally called Steinweg, and they came from Germany. They immigrated to America, and they called themselves Steinway, and part of the family remained in Germany and sold their German business to some other company, who then changed their name by name change in the Weimar Republic to Steinweg. So you have Steinway and Steinweg competing in the same market, and one is famous, and the other one is also famous, and so they litigate against each other. Very difficult to predict the outcome. Usually people sit down in the end and make an agreement, because it's practically impossible for the courts to resolve these issues. In Germany, you have fights between Peek and Cloppenburg, who are located in different locations, but not the same family. The same family originally, but they can't agree. Very difficult. Anyway, I think I have a few other cases, but I will not deal with them because we're reaching coffee time. Okay? I could talk about them, but I will not. So I finished with my most pleasant example that I have on showing you how the Court of Justice deals with complicated issues. This is, again, the famous the Bear case. And I've extended my time by a few minutes. I do thank you very much. I know that some of you haven't been able to see me because you're sitting behind the column there. Thank you very much for your attention. It's a beautiful